The first Trump administration rolled back hundreds of environmental regulations. I have no reason to believe it won't do the same this time, perhaps even more significantly. No, I don't bring in my own sense of morality. I try to understand what the language of the statute means and what Congress intended by passing it. That's my job.
The pertinent example for me from that actually is you say in your book, I'm against the death penalty. However, if I believe that the use of the death penalty is defensible in this case on the basis of the text, then that is the decision you will put in place, as you emphasize with the analogy of the scientific method. With the aforementioned example of the Voting Rights Act, you did your best to make it difficult for the Supreme Court to overrule Article 5, even though you didn't directly oppose it. So where is the place for morality in the legal profession? Linking back to the political question, it seems like we got a little bit of movement within still quite a strict interpretative work.
Judges apply the law. That's what they do. They apply the law that Congress passes, or the Constitution. And that's their job. Their job isn't to produce a result that the judge thinks is right as a matter of policy or even just. The judge's job is to apply the law that Congress passes to the facts before him. That's it. Now, a lot of people think, well, you should be producing results that are morally right. Well, that's not my job. Congress is the one that passes the laws, and they're politically accountable for them. My job as a judge is to apply those statutes. Now, I do it by trying to understand what the Congress was intending. So, one of the cases I talk about in the book is a Supreme Court decision. It's called Cummings, and it involved a woman who was trying to get a interpreter. She was deaf, an interpreter in a federally funded program, and they denied it, and she sued, and the Supreme Court ruled against her because it said it's not fair to the employer to make him pay for emotional damages to this woman. The employer never expected that. What's wrong with that decision is that the disability law that was in place, Congress passed that to protect people with disabilities and to give them a remedy for being discriminated against. And that was the purpose of the statute. And that's the job of the judge, is to apply the statute according to the Congress's purpose, not to produce what you call a moral result. That's up to Congress.
But clearly, you would perhaps agree that there is often, as we've discussed, the level of interpretation.
Of course.
Yeah. So when you're kind of in that seat making those decisions and you need to make that interpretation, do you try bring in some sort of objectivity, or do you try bring in some sort of your own sense of morality as well?
No, I don't bring in my own sense of morality. I try to understand what the language of the statute means and what Congress intended by passing it. That's my job. That's my only job as a judge. It isn't to produce a result that I like. And by the way, I talk about this. I give some examples of this in the book where I wrote opinions that produce results that, had I been in Congress or on the agency, I would have voted the other way.
One example where you didn't necessarily disagree, but where you trying to fill in the purpose of the legislation was with your decision, perhaps in an area which you're most famous for, which is on the environment and the Clean Air Act. And you interpreted the purpose of it as to the Clean Air Act stating that companies could only produce X amount of whatever chemical. You made a decision that companies shouldn't be allowed to produce any, or you agreed with the decision that companies shouldn't be allowed to produce any of a certain chemical. And this was an important ruling, right? But you interpreted it purely on the basis of what you thought the legislation was trying to do, regardless of how it might be put across.
Yeah, I think the case you're talking about is Massachusetts versus EPA. And the question in that case was whether the agency, the EPA, had to regulate carbon dioxide. carbon dioxide is the chemical that is most responsible for global warming, or is responsible along with other chemicals for it. And the Bush administration took the position that carbon dioxide wasn't a pollutant, and that even if it was, they didn't have to regulate it because they could deal with it through other techniques. And I looked at the Clean Air Act and the definition of pollution, and it seemed to me quite clear that carbon dioxide was a pollutant under the statute. I didn't reach that decision because I thought it was necessary to regulate carbon dioxide. I reached that decision because I concluded that that's what Congress had decided. And fortunately, the Supreme Court agreed with me 5-4.
What do you think about the developments now of the environment in relation to the judiciary now that Trump's been elected?
Well, I think there is cause for concern. Look, all we have to do is look back at the first Trump administration. I mean, we don't have to guess here. The first Trump administration rolled back hundreds of environmental regulations. And I have no reason to believe it won't do the same this time, perhaps even more significantly. We don't really have to guess about this.
Yeah, you spoke about your friendship in the book with Ruth Bader Ginsburg, who was very important in acting as a kind of check and balance, you say as well, in working against this kind of movement. Could you maybe talk about her role as well in relation to protecting legislation like this and her role in the Supreme Court before she unfortunately passed?
Well, her view about the law was the same as mine, and that is that a judge's role is to apply the law that Congress has passed. She was before she came on the court, she was one of the most important litigators in the United States on women's rights issues. She won several big cases in the Supreme Court, just like Justice Marshall did before he went on the court. She had a formidable civil rights record before she was on my court for 10 years and then the Supreme Court. In fact, when I was appointed to my court because she had been appointed by President Clinton to the Supreme Court, and I was appointed to fill her vacancy on my court. She was the same kind of judge I hope I was.
Thank you, Judge Tatel. I think if it's okay with you, we'll move the topic on a little bit. So this one's a bit more personal to you. I was wondering if you could maybe tell us about your process of coming to grips with disability and being blind.
Well, that's the other thread in the book. Along with my views about the courts, is my personal history of dealing with declining sight. When I was 15 years old, I was diagnosed with an inherited retinal disease called retinitis pigmentosa. All I was told at the time was that I couldn't see very well at night at that point, but I was told that my sight would decline over years. No one knew how fast, and no one knew then whether I'd lose my sight. But in fact, that's what happened. Over the next 20 years, it declined steadily, and by my mid-30s, I couldn't read any longer, and I began to work with readers, and I tried to learn Braille, though not very successfully. And a few years after that, I got a mobility cane and used that for quite a long time. And then 6 years ago, I took the big step and got a guide dog. During most of that time, when I was still functioning as a sighted person, as a teenager and a young lawyer, I had lots of tricks for covering up my declining sight. I didn't want people to know about it. I didn't talk about it. I hid it. And I tell all those stories in the book. Some of them are funny. Some of them aren't so funny. And then by the time it was obvious to people that I had a visual disability, especially because I had a cane. I still never wanted to talk about it. When I was on the court, I didn't want to be known as the blind judge. I wanted to be known as the judge who happened to be blind. So I tell the story in the book. I write extensively about this. Writing a memoir was a very personal experience and required me to think deeply about my life and how I reacted to declining sight. And I've tried to tell that story in the book.
For 54 years, they were trying to get Roe v. Wade terminated, and I did it. And I'm proud to have done it.
So the checks and balances, which have been so critical to preserving our constitutional system and individual liberties, largely don't exist now. My concern is that in the past decade, this Supreme Court has been less faithful to those principles than we would like. And that's dangerous for a democracy. This book tells the story of so many people, that people see their own lives in my book.